This description should identify what was searched and how. See, the judge now doesn't even trust the district attorney.
There needs to be an investigation as to where those records are, and if they are not there, meaning they've been deleted, I hope there's consequences.
And we are back, y'all. Thank you for watching today. Go ahead and hit that like button, people. You know, it helps us out a ton, and it helps you because it helps us. Now, y'all, the latest on the Fani Willis saga, it's like a slow moving train that you know is about to crash into a whole neighborhood, but nobody can stop it. Like, Fani just can't stop all of these forces that are aligned against her. She has Judicial Watch. That's probably the #1, first and foremost organization that is just on her neck.
I mean, Judicial Watch is happy to do the heavy lifting. It's what we're here for, right? But isn't it outrageous that we're the ones doing it?
As you can see from your screen, Judicial Watch, Fani Willis ordered to turn over anti-Trump collusion records to the court. Now, just to give you a bit of background, Judicial Watch filed a Freedom of Information request with the Fulton County DA's office, that's Fani's office, requesting certain documents that may show that Fani's office or Fani herself was colluding with the January 6th committee and with Jack Smith, who was investigating Donald Trump on a federal level. So they filed this Freedom of Information Act. It was the Georgia version of it, but they filed this Freedom of Information Act request, and Fani's office repeatedly said that there were no documents, okay?
We're the ones figuring out that they were hiding collusion records? Congress has been asking for these records. They've gotten nowhere. They've literally gotten nowhere.
Eventually, Judicial Watch was able to conclude that there was at least one document because they obtained that independently. So Fani's office comes back and says, oh, here's the document. Now, they just give Judicial Watch the same document that Judicial Watch already has. So this leads to Judicial Watch suing the office, Fani's office. Fani's office had to pay Judicial Watch over $22,000 in attorney's fees. And now they have been able to identify at least 212 pages of records, okay? So that's where we stand now.
And plus, she didn't show up in court to answer our lawsuit. As far as I'm concerned, she waived all these privileges. You don't show up, you lose. Literally, she's already lost.
So let's read. Judicial Watch announced today, that's today, that Georgia District Attorney Fani Willis was ordered to turn over 212 pages of records to a state court judge. The court also ordered Willis to detail how the records were found and the reason for withholding them from the public. See, she originally withheld these records. They said that there were no responsive records, that they didn't have any records. Then they had one record. Now they have 212. The court order was issued on March 7th in a Judicial Watch lawsuit filed after Willis falsely denied having any records responsive to Judicial Watch's earlier Georgia Open Records Act request. All right, so let's take a look at the actual court order. Let's see what the judge says, okay? In August 2023, Plaintiff Judicial Watch, Inc. submitted an open records request to defendant District Attorney Fani Willis, seeking all documents and communications sent to, received from, or relating to Special Counsel Jack Smith. Defendant claimed to have no responsive records. Doubting this, plaintiff, that's Judicial Watch, sued and has since secured a default judgment against defendant, who, it turns out, does have responsive records. After several non-searches, one court order, and at least one actual search of unknown thoroughness, defendant revised her answer to, in essence, quote, I do have records, but you can't have them, okay? Except this one record you already had and gave me. This is what the court is writing about Fani. Fulton County, this is your district attorney that you just voted into office. Unsurprisingly unsatisfied with this post-adjudication response, plaintiff on December 17th, 2024 petitioned the court for the appointment of a special master, okay? So let's skip down and see what happened. On February 28, 2025, the court held a hearing on plaintiff's motion at which both sides presented argument and made various factual representations, to include an assertion that the universe of responsive records consists of 212 pages, some of which may be duplicate. From these presentations and representations, a review of the parties' pleadings, the court rules the following. No special master for now.
We've asked for a special master, which would be a court-appointed individual who would oversee and be in part responsible for making sure the search is appropriate.
Fani has to deliver to the court within 5 business days of the entry of this order the 212 pages. So these 212 pages have to go to the court. So that those documents should either be with the court or shortly the court should be able to review those documents. Along with the documents, Fani should provide a list indicating which documents arguably fall under which exemptions, and Fani also shall provide the following: a detailed description of the search that was conducted that yielded the 212 pages. This description should identify what was searched and how. See, the judge now doesn't even trust the district attorney.
We still don't have a clue as to how they searched or where they searched and why they keep on finding records every time they do a new search.
The district attorney is the person responsible for enforcing the law in Fulton County. The judge doesn't even trust the district attorney to follow the law. You see this? The search terms used to search email accounts and answer to the question of whether cell phones were searched. The court will review all these submitted materials to determine if any are, despite defendant's claimed exemption, subject to disclosure under the ORA. Should any of the submitted documents be deemed disclosable, the court will notify counsel for defendant so that the defendant can reply, basically. So y'all see? Do y'all see this? Listen, y'all. This is, listen. Y'all already know. I'm not going to go off on a rant about this. I want to hear what y'all have to say about this. Though I already have an idea what you'll likely say, I want to hear what you have to say. So y'all, before we go any further, please stop, hit the share button, send this out to somebody. Just put in their email, WhatsApp, their Facebook, text message, whatever. Send it to somebody. Help your boy out. And also, if you're not a subscriber, please do subscribe and let me know in the comments, what does this kind of irritate you like it does me? I have nothing against Fani Willis. I don't know her. She's probably an excellent prosecutor. But why not follow the law? Why not just follow the law? I mean, you are the person who is in charge of that. You know the law. You enforce the law. Why not follow it? Y'all let me know in the comments. Thank y'all for watching. Love y'all, and we'll see you back in the next one.
We want Congress to follow our lead. We want the Justice Department to follow our lead. We want Georgia officials to follow our lead over this cover-up in Fulton County. And this is quite the scandal. And of course, Congress has these emails, or at least they ought to have any communications. And there needs to be an investigation as to where those records are. And if they are not there, meaning they've been deleted, I hope there's consequences. And that's up to Speaker Johnson and his team to figure that out.